Now to an update to a story that triggered a national debate over self-defense laws in this country. Prosecutors today withdrawing assault charges against an Ontario man who fended off a home invader last summer. In August, Jeremy David McDonald confronted the assailant who broke into his apartment carrying a crossbow. After the altercation, police charged McDonald with aggravated assault and assault with a weapon in his own home. His lawyers argued he was acting within his right to defend himself. Today, the Crown attorneys told the court there is no longer a reasonable prospect that McDonald would be convicted, and so the charges withdrawn. Our next guest, Rishi Gill, is a criminal defense lawyer, and it's hard, I know, to follow this case from afar. Not a lot of details have been put out, but let's go back to August when those charges were laid. A guy defending himself in his house. Were you surprised that those charges were laid?
I wouldn't say I was surprised, but I would have thought that they would have taken a bit more time to consider their next moves on that. In Ontario, which is different from BC, the police actually have the ability to charge, which is in BC only the Crown can charge. So the police decided at that point that there was enough evidence to at least move forward with the charge. But there's certainly an issue to be explored, and it was explored at the end of the day.
I think that based on the news reports that I've seen, that the Crown prosecutor today told the court that they have now studied the forensic evidence and medical records, and on that basis, they are withdrawing the charges. And as I read that, I thought to myself, why wouldn't that have been studied even by police earlier before laying the charges? I mean, to lay a criminal charge against somebody is serious business, and to live with that hanging over your head for months before the evidence is properly assessed seems puzzling to me. What about to you?
I think I can totally see why it would be puzzling. So in that dimension, that makes sense. I will say, as being someone who's been part of the justice system for more years than I care to talk about, people think it's this really finely tuned system where things get done exactly how they should be done, but a lot of times you find, as with anything, and it's unfortunate, but with anything, it kind of moves up against deadlines. And the pressure to actually examine something at a very clinical forensic basis sometimes doesn't occur till you're much closer to having to make a very crucial decision, meaning going to court and having to deal with the judge. And that's when people's focus turns.
We should underscore something you said earlier, but people in the rest of the country may not fully understand this. Here in British Columbia, it is the Crown that decides whether to lay charges. Yes. The police investigate, and then either they decide that not to, no charges are warranted, but if they think charges are warranted, as I understand it, the file ends up on the Crown prosecutor's desk, and then they have to determine whether charges are in the public interest and whether there's a substantial likelihood of conviction. And that's exactly what happened here, except months after the charges were laid, that based on the evidence, there wasn't a substantial likelihood of conviction. Let's talk about the other issue. You're a criminal defense lawyer, you know the criminal law. Let's talk a little bit about self-defense. And somebody breaks into my home and they have a weapon. Generally speaking, in the law, what am I authorized to do?
You're authorized to defend yourself, but the trick, if I can put it that way, is that it can only be a reasonable amount of force that one can use. If, in this case, the person, Mr. Breen, I think his name was, who was the actual assailant, he had a crossbow, which is a pretty deadly thing. You don't really see that happening very often where somebody's carrying around a crossbow. And he was met with, I think, a large degree of force. And I think there was a knife wound that was involved. There was a weapon of some sort used by Mr. McDonald. Now, for whatever reason, the police found that there was an overabundance of force used by Mr. McDonald. But in that situation, I would say that as a defense lawyer, that would be a very good case to take to a jury if it came to that. So I think the Crown made the right call. I think they were looking at a very difficult prosecution. But whether that could have been done earlier, that's something the Crown's going to have to consider when they look at how they handle the file.
One last question. As you say, you've worked in the criminal justice system for a long time. You live in a world of rules, of evidence, and of kind of measured decisions. Politicians live in a world of sound bites. And so the Premier of Ontario, Doug Ford, said, if the guy breaks into your house and has a crossbow ready to kill, it's free game.
Doug Ford's an interesting character. I think he's a great politician. I don't know if he's going to make the most effective justice minister, but I think that I've always said that the public has every right to be curious about these decisions and to really examine them and to want to know what's happening. But politicians have a different responsibility, which is to have some sense of, I think, rationality and to keep the public informed in a reasonable way. I don't think those comments are helpful, but I see where he's coming from. But one doesn't have ultimate authority to do whatever they want if somebody crosses the threshold of your residence. The person's home is their castle, so to speak. That doesn't give you the right to go to town, if I can put it that way, which is what you see in the States, where they have those stand your ground laws. And you see a lot of people getting killed for just knocking on the wrong door, right? And we don't want to end up to be in that situation.
Rishi Gill, criminal defense lawyer. Always nice having you on the show. Thank you very much.
Thanks, Steve.